Hi, thank you for tuning in. My name is Graham Wallis and I'm a Solicitor-Advocate and Company Director of Wallis Solicitors Limited. I'd like to talk today about the police caution. So imagine the situation where you have been arrested and taken down the police station and put in a room, and the police want to ask you some questions under caution. This is known as a PACE interview from the Police and Criminal Evidence Act. And the caution is fairly straightforward. The caution is this: you do not have to say anything, but it may harm your defence if you fail to mention, when questioned, something that you later rely on in court. Anything you do say may be given in evidence. Okay, so what does that mean? Well, the caution can be split into three parts, and frequently the police officer who is conducting the interview will actually explain the caution in greater detail. The first part is reasonably easy. You do not have to say anything. That means that if you choose, you don't have to answer the officer's questions. You can say nothing at all, or frequently people use the expression no comment. So an officer can ask a question and the reply can be no comment. The police have no power to make a suspect say anything, make a suspect make any admissions. That is not within their power. And the third part of the caution is likewise reasonably straightforward. Anything you do say may be given in evidence. What that means is the interview is being recorded, sometimes in handwritten notes, more usually either audio or visual recording or both. And that means that if the matter ever goes to court, then a record of that interview, be it on the CD-ROM or on C90 cassette, can be played to a court. Now, the middle part of the caution is perhaps the most complicated. It may harm your defence if you do not mention, when questioned, something that you later rely on in court. What that means is, if you are asked a question by the officer and you choose not to give an answer when questioned, and that matter then goes to court, at court it might harm your defence that you chose not to give an answer. That's frequently referred to as drawing an adverse inference. So, for example, if a suspect was suspected of stealing a motor vehicle and gave no comment in questioning and went to court and at court provided an alibi, then the court might consider why that interview, the suspect in interview, didn't give that alibi in interview. If an explanation was available and the person being interviewed didn't give the explanation, a court might ask why not. And a court might conclude that the reason why not is because between the period of time between interviewing and going to court, the suspect has perhaps come up with a story. So, to recap, the interview under caution is in three parts. You do not have to say anything. However, it may harm your defence if you do not mention, when questioned, something that you later rely on in court. Anything you do say may be given in evidence. Remember, if you are arrested and taken to the police station, you are entitled to have legal representation. You are entitled to have a solicitor of your choice present in interview with you. Thank you.